welcome again. Last time I tried to be forthright in outlining the true position regarding the law of the land and our individual responsibilities in upholding that law. In fact, the responsibility for upholding the common law is shared by every Crown subject. When speaking of the Crown, I don't refer to the monarch. The monarch merely represents the Crown. The Crown is an abstract concept used to indicate the unseen presence of the ultimate repository of the authority of the law and the source of the dispensation of justice. Some refer to the ultimate authority as God, and if they wish to do that, that is their prerogative, so long as whatever authority the administrators may exercise doesn't overstep the mark of affording everyone the same level of validity before the law. That obviously precludes the exercise of ecclesiastical authority in any degree of favour towards subscribers to any one form of religious belief, and means that the law and justice remain entirely within the realm of the exercise of reason, without the incursion of any particular doctrinal conviction. This reference to the Crown occurs because the personage which some erroneously believe currently represents the Crown has recently become the focus of some attention. On Richard Vobes's excellent channel, on which William Keat and I have appeared, was featured the script of a letter to the King, inverted commas, composed and supported by various elements of the freedom movement. On another very informative channel hosted by Laura Nina, again on which I've been graciously granted time, there is visible a lengthy interview with Edward Fitzgerald, author of the widely acclaimed book Smoke and Mirrors. There is apparently some controversy over the authorship or otherwise of elements of this letter, with claims of plagiarism or some similar irregularity. It is only to the concept of writing to the person many people describe as the King that I'm addressing this talk, and this follows on from my remarks in the last. In that, I stated that appealing to people classifying themselves as public servants, the government or the police, was not only a futile activity, but actually unlawful, to the point of committing or aiding and abetting treason, by falsely ascribing lawful Crown authority to those devoid of it. To fully understand this concept, we need to analyse exactly what is the monarch's oath of office and its relationship to all other oaths of public office. To do this, we can get an excellent insight from the notice of lawful objection to Crown agent or conditional acceptance, depending on circumstances, which we use to lawfully rebut usurpers from exercising unrighteous dominion over us or our families. Here are some quotes from Exhibit B, the Baron's petition, which explain the position with wonderful clarity. I will display some of this section, and the full text will be available in the comments box. Viewers are advised to pause the video to read these excerpts. The exhibit then goes on to enlist some of the totally unacceptable propositions from the EU. There then follows a list of the 4 barons signing the petition, with the names of the full committee of 25 also appended as signatories. The Queen's private secretary had requested a letter of amplification to accompany the petition to the Queen, the barons' reply to which request is given in full in Exhibit B. The body of their reply commences thus, quote, "The Treaty of Nice raises issues of major constitutional importance. It directly threatens our rights and freedoms and undermines oaths of loyalty to the Crown. Such fundamental matters cannot be considered merely the stuff of day-to-day politics. They directly concern the Crown, the Constitution, and every British subject, including generations yet unborn. We find ourselves living in exceptional times, which call for exceptional measures. Hence our petition to Her Majesty, which exercises rights unused for over 300 years, Clause 61 of Magna Carta, which were reinforced by Article 5 of the Bill of Rights. As you know, the wording of Clause 61 says, and laying the transgression before us, petition to have that transgression redressed without delay. And we shall procure nothing from anyone, directly or indirectly, whereby any part of these concessions and liberties might be revoked or diminished. And if any such things has been procured, let it be void and null. We have petitioned Her Majesty to withhold the royal assent from any bill seeking to ratify the Treaty of Nice, because there is clear evidence, which we shall address in a moment, that it is in direct conflict with the Constitution of the United Kingdom. It conflicts with Magna Carta, with the Declaration and Bill of Rights, and above all, with Her Majesty's Coronation Oath and the oaths of office of Her Majesty's ministers. Every one of these protections stand to this day, which is why they are now being invoked by our petition. Ultimately, our supreme protection is Her Majesty's obligations under the Coronation Oath. The Queen has solemnly promised to govern the peoples of the United Kingdom according to the statutes in Parliament agreed on and according to their laws and customs. Her Majesty also swore to preserve all rights and privileges as by law do or shall appertain to any of them. From the spiritual point of view, it is unimaginable that Her Majesty would seek, in effect, a divorce from her duty. From a secular point of view, the Coronation Oath is a signed contract. Recent statements by ministers, and by the previous Prime Minister, confirmed that they would not advise any measure which might tend to breach the Coronation Oath, nor betray Her Majesty's promise to her loyal subjects. Her Majesty accepts the advice of her ministers. Conversely, it is their duty to advise in accordance with the Coronation Oath. They cannot lawfully advise a breach, nor can they gain or remain in power without swearing allegiance to the Crown. Yet the Treaty of Nice represents precisely such a breach, and it has now been signed by the Foreign Secretary using the royal prerogative. The duties arising from the relation of sovereign and subject are reciprocal. Protection, that is, the security and governance of his dominions according to law, is the duty of the sovereign, and allegiance and subjection, with reference to the same criterion, the constitution and laws of the country, form in return the duty of the governed. We have already observed that the prerogatives are vested in him for the benefit of his subjects, and that His Majesty is under and not above the laws. For such words to have meaning, the act of signing the Treaty of Nice by the Foreign Secretary demonstrates that ministers have de facto renounced their oaths of allegiance, unquote. The following quote indicates the sound and constitutional reasons the barons stated in support of their position. Quote, "As the Act of Supremacy and the Bill of Rights put it, all usurped and foreign power and authority may forever be clearly extinguished and never used or obeyed in this realm. No foreign prince, person, prelate, state, or potentate shall at any time after the last day of this session of Parliament use, enjoy, or exercise any manner of power, jurisdiction, superiority, authority, preeminence, or privilege within this realm, but that henceforth the same shall be clearly abolished out of this realm forever." So it is clear that no one, neither sovereign nor parliament, nor government, nor people, may tamper with, dismantle, destroy, or surrender our Constitution. We are all tenants of it and trustees. We inherited these rights, and we have a supreme responsibility to pass them in good order to future generations. They are not ours to discard or diminish, which is why oaths of allegiance place an essential limitation on Parliament's power, and the Queen's Coronation Oath is crucial. The Coronation Oath is a moral obligation, a religious obligation, a sworn obligation, a contractual obligation, a statutory obligation, a common law obligation, a customary obligation, an obligation on all who swear allegiance. It is the duty of government, and it is sworn for the nation, the Commonwealth and all dominions. The Coronation Oath is a peak of a pyramid, and all subordinate oaths are bound by its limitations. The armed services swear allegiance to the sovereign, not to the government of the day. This helps clarify the principle that allegiance is necessary and not optional, an essential part of the checks and balances of our Constitution. Without these oaths and their lawful enforcement, we have little to protect us from government by tyranny. Our political freedom is absolute. The Bill of Rights says so. It cannot be limited in any way. Her Majesty is rightfully inscribed on our coins of the realm as fid def and lib def, libertatis defensor, defender of the freedom of the people. It has been suggested to us that a referendum or plebiscite might be an acceptable response to the question of ratification of the Treaty of Nice, but we do not hold that view. A referendum or plebiscite which purported to make lawful the infringement of our common law rights would itself be unlawful. We come back to the oath of allegiance. Magna Carta says, "We will appoint as justices, constables, sheriffs, or other officials, only men that know the law of the realm and are minded to keep it well." How can such officers of the Crown organise such a referendum or plebiscite? It is clear from the responses we obtain from our notices sent that the recipients either don't read them, or if they do, they might ask one or two questions from their legal departments to the effect that, is this stuff legal? Do we have to pay any attention to it? And the answers they receive clearly indicate that they are told by their superiors to just carry on, that nothing will come of it. Any alleged public servant, police officer or politician would be extremely ill-advised to follow such counsel for this reason. These are facts of law, and the information is in the public domain. It is only a matter of time until enough people understand the implications, and those responsible for upholding this unmistakably defined treason are called to account. The laws which facilitated the exercise of these rights have existed for hundreds of years, and so have the penalties for bringing about their invocation. We speak of life in prison and total asset stripping for sedition, while treason is a capital offence. Article 61 itself specifies the method of asset stripping of the monarch themselves, namely the seizing of castles, lands and other assets. Only their persons and the persons of their wives and children are to be inviolate. It is a foolish public official, with an oath subservient to that of the monarch, who would imagine that they would be subject to lesser retribution for the same offences once the public understands that all are equal before or under the law. It is equally ill-advised to appeal to Charles Windsor, who is only pretending to be the king, to continue acting as if he has lawful entitlement to that office. He does not. Such actions only support the false notions in uneducated minds that there is even a shred of legitimacy to the prancings and poncings about of people like Mr. Windsor and his ilk. It is the barons who braved the opprobrium hurled at them for invoking the law and doing their inherited constitutional duty who deserve praise. Mr. Windsor, who as an open and avid supporter of the unelected mobsters who think that because they have access to large sums of money that they are immune from the law, is by his own support of such evil as an unelected tyranny unworthy of any public office, let alone that of monarch. He may have sincerely held beliefs, not established as scientific fact by any means, about climate catastrophism, but that in no way establishes his right or authority to coercively override the liberties of his fellow crown subjects, any more than would the beliefs of any cleric grant them the right to establish a theocracy of some kind. Charles Windsor's support for posers like Klaus Schwab with his agenda for global authoritarianism renders him, by his own admission, totally unfit for the position of public trust which sits upon the shoulders of the monarch, the protector of our constitution. I urge all to gain an understanding of the constitutional law involved and to utterly turn their backs upon these pretenders and have nothing to do with them. The law demands no less. As stated before, the law is clear as to the mechanism and solution to this high treason. Each crown subject is to disavow any allegiance to a lawfully deposed monarch or anyone else claiming to act on crown authority by swearing or affirming their allegiance to the Constitution as specified in Magna Carta 1215. Adopting any other means of dissent is not only ineffectual but unlawful. We are all on notice to fulfil our constitutional duties or face the possibility of one day being called to account before a jury of our peers as to why we did not. Thank you for watching.